Welcome, everybody. Can you hear me okay? Thank you so much for coming today. This is a really important presentation, but I am going to let the sponsor and the attorney take it from here. So thank you.
Thank you, Suki. Good morning, everyone, and welcome to today's program, to the Distinguished Speaker Program. My name is Leah Freitas-DiCanio, and I am a Medicare Solutions representative with Mass Advantage. So Mass Advantage was created right here in Worcester County for all the people that live in Worcester County, and we're a Medicare Advantage plan. And our network consists of all of UMass Memorial Health, including all the doctors and all the specialists. We offer HMO as well as PPO options. But enough about Mass Advantage. Let's get to the reason that we're here today. Today's program will focus on elder law, how to prepare for your future, and Stephanie K. Fattman, Esquire, Register of Probate, Worcester County, is here to discuss how to probate or protect an estate, competency and incapacity, who can make decisions for me if I cannot, guardianships and receiving long-term care, information about the Worcester Probate and Family Court and resources. So please, without further ado, let's give a very warm welcome to Attorney Stephanie Fattman.
Good morning.
Good morning.
Hi there. As mentioned, I am Stephanie Fattman. I'm the Register of Probate for Worcester Probate and Family Court. Thank you all for attending this luncheon today. Thank you for Mass Advantage for sponsoring, and for Suki for all of your hard work in organizing all of this. This is great to be back. We haven't been in Worcester for the past couple of years, but I see a lot of familiar faces, and it feels so good to be back here and giving this presentation again. So today we are focusing on the Fattman Family Forum, and we're going to be giving some information on guardianships, both of an incapacitated and of a minor, and we'll be going over some estate planning, what's important in your estate plan, and wills, and how to avoid the probate court. And so with me today, I have my assistant register, Sean Gallagher. He'll be giving the presentation as well, and we also have assistant register Lisa Delgado in the back. So we are going to structure this presentation giving some general court information. We'll go through the PowerPoint slides. Hopefully you can follow along. We'll point you to some resources in the bags that we've left on your table. We'll open it up for general question and answers. With a huge group like this, I'd like to leave the questions as broad as possible. So if you could ask some general questions, we'll certainly give some more court information and some feedback. And then we've also set up a resource table for you over on the stage, and we'll have a sign-up sheet. We see some familiar faces in here, so if there's anybody that has a specific question about their case or something going on in your life that's very detailed, the three of us will stay around until lunch is served, and we'll answer those specific questions for you and try to help and give you some paperwork and some information and guide you along the way. All right, so first, let's see. What is the Probate and Family Court? So we serve litigants in each county. There are 14 counties across the state, so 14 probate and family courts. Worcester County covers all 60 cities and towns in Worcester County, and we're the second busiest court in the state with about 20,000 case filings each year. So we're a very busy court. And we have jurisdiction over all family matters, so think divorce, child support, child custody, adoptions, and then we also handle estate matters, so probating an estate, guardianships, conservatorships. And my job is to maintain the record. We have over 800,000 records floating around our court at any given point, and my job is to keep responsibility of all of them and get the documents all together and prepared to go over before the judge. I'm here today to give you information, not legal advice. We have plenty of resources to offer you legal advice, but in my capacity as registrar, I can't be advising you, so I will give you as much information as possible about the court system. Who am I? Again, Stephanie Fattman. I was elected to this position in 2014 and re-elected in 2020. So it's a very unique position. It's an elected position in the court, one that most people aren't very familiar with. In Massachusetts, our judges are not elected, but there are some clerks that are, so myself and several others are elected. And my whole job has been to organize the court and make it run more efficiently and more effectively. We have worked hard on community outreach. My whole goal for you today is to let you know about the court and what to expect from the court process before you ever even have to step foot in the court. And we've had several accomplishments we're very proud of. We've worked hard to build our adoption program. Adoptions are really the one positive thing that we do in the probate and family court. So we've partnered up with some law firms to give away Build-A-Bears to every adoptee. We've also launched a second registry up in Fitchburg. We've launched the Fitchburg Satellite Registry. We've returned more than $3 million to families through a court purge that hadn't been conducted since 1992. When I entered office, we were sitting on all of this money, and we've been able to research and find families that had money missing in estates, which is why we want to focus on our estate planning, and return that to different family members over the years. We've built spring baskets to donate to families across the counties. We've tackled the opioid task force, and we've built up an internship program letting different students, especially from Worcester and surrounding towns, come into the court and learn a little bit more about what it's like to work in an office and professional environment. So with that, we will dive into guardianships. We'll start with guardianships of a minor. And we are seeing thousands of children across Massachusetts who don't live with their parents. They live with their grandparents, and grandparents can provide careship in different ways. In Worcester Probate and Family Court, we provide guardianships, and we do more than 2,000 cases each year. And there are many grandparents raising grandchildren these days. You are certainly not alone. Many reasons for that. We see parents that are unfit because of mental instability, domestic violence, homelessness, abandonment, incarceration. And grandparents often step in because a child needs medical assistance or a parent is overseas or, of course, death. One of the biggest reasons we are seeing for grandparents raising grandchildren, the opioid epidemic, especially over the years of the pandemic, but in the last year, we've seen an increase over 3% in rise of guardianships due to the pandemic. You are not alone if you find yourself caring for a grandchild in this capacity. We have some resources in your packet, and we've also launched the Kinship Navigator project in the Worcester Court. So every Tuesday, this group comes in. Again, the information is in the bags, but they come in and they'll work with you. So if you're a grandparent raising grandchildren or any kinship provider in any way, we can get you some resources and some assistance that you'll need to help navigate the process. And there are 3 ways for a grandparent to assume responsibility for a grandchild. There's caregiver, legal guardian, and adoptive parent. And always we want to act in the best interest of the child. And so we'll start with the most simple, which is the caregiver. Caregiver is the caregiver authorization affidavit, and this is not something that you file with us in court. And so basically, this is a document that allows a child to live with someone other than a parent, and for that person to assume responsibility to make medical and educational decisions for the child. And it doesn't take away the parent's right to make decisions, so we see this a lot, where both grandparent and parent want to make these decisions together. This is your avenue to do that. You can assume certain responsibilities, and you can take these documents to schools or to doctors and help make those decisions without completely taking over as you would in a guardianship. We come in the court system as a legal guardian, so we see a lot of legal guardians of a minor. And this is where the grandparent gains both physical custody and responsibility of the child. And once this happens, the biological parents are no longer making those decisions for the child. So you'll come in and you'll file a petition for a guardianship of a minor with us. It'll allow you to, the guardian, to make these decisions for the child. To be a guardian, you have to be 18 years old, live in the United States, and not have a criminal record of child abuse or neglect. So anyone can become a guardian of a child if you find yourself in that situation. We also do guardianships of incapacitated. Very similar to guardianships of a minor, regardless of any of the estate documents in place, the guardianship of an incapacitated will come in to help make decisions on support, care, education, health, and welfare of an individual. So we get often asked, how would somebody know that they're incapacitated or unable to make these decisions? There will be medical documentations in place. They're diagnosed with a condition that impairs them from receiving or evaluating certain information. So there's clinical medical records that help put this guardianship of an incapacitated in place. In the court's role, we of course review all the information within 60 days, and then the guardian would be put in place by the judge, and this of course doesn't revoke the healthcare proxy. Healthcare proxy takes precedent over the guardian. Conservatorship, very similar, but this is for your assets, for your money. You're managing your business and property. So any one that cannot make their own personal business decisions or decisions about their assets, a conservatorship would be what goes into place. We handle those in the probate and family court as well. Next, we'll focus on estate planning. Estate planning is the preparation of your documents to manage your assets in the event of death or incapacitation. And so this is probably the bulk of our presentation and why we're here today, and the goal is to get you to manage your estate plan and make sure it's updated. If we leave with nothing else today, I want you to know that you should have an estate plan in place, or if you have a loved one who is getting older, a parent or an aunt or someone who needs to have their estate plan in order, please, out of this presentation, make sure that you leave today knowing that an estate plan, your estate plan should be put in order. So while we oversee the probate and family court, our goal is for you to avoid the probate and family court. We never want to see you in the probate and family court. And so how do we do that? You have a proper estate plan that's going to help you avoid having to probate an estate. So you probate an estate when somebody's died with property in your individual name. So things like a bank account, real estate, stock accounts, those properties we want to make sure are not in your individual name. Things that go on to a beneficiary or life insurance, a 401k, those are not subject to probate. Those are not probate property because they pass to a beneficiary. So really we see a lot of probating estate for bank accounts or houses. And so what you need to do, there are different ways that you can file in the probate and family court should you need to probate an estate. You can do a formal or an informal. They can be a lengthy process, 30 to 45 days just to start processing your paperwork. They can be expensive, several $100s just to file with us. And so that is what we want to try to avoid for your futures and your family. We want people to not have to spend that money to file it and take the time to file an estate. There is a voluntary administration, so if you have an estate worth less than $25,000, so a small bank account and really no other assets, you can have a family member file a voluntary, and that is a very simple court process. That might be one that many of you will have questions on, an easier way to handle the probate process. Again, avoiding probate, your assets will be titled prior to your death in a way that they're not in your name alone. If you have a great amount of assets, you can also place your assets in a trust. There are some resources in here on how to contact a trust attorney. You'd want to contact a trust attorney and set up a trust to help protect your assets. Also, you can place all your assets into joint ownership, so things like your house, or as I mentioned, your bank accounts, or you make your accounts payable on death to another. Have beneficiaries. You can set up your bank accounts to have beneficiaries as well. You'll want to do that to try to avoid the probate process. Our essential documents, the number one on our list, of course, is a will. The will is your roadmap for what happens to your assets. And so we see a lot of this, and I'll have a lot of questions on wills, so I'd like to allow for some time for you all to ask those questions. But the most important thing to know is your will is going to outline where all of your assets go and who gets what. And there are more scenarios than we would have time to discuss today of what ifs and what could happen, and you don't always anticipate that somebody would pass away that you've left your assets to, and then where does it go after they've passed away? Does it go down to their next of kin? Does it go to another relative? These are different things that you'd want to outline in your will, and so it's really important to think of everything when you think of a will. To have a valid will, you have to have your document signed by yourself, you have to have it notarized, and you have to have it witnessed by two individuals. And so often people ask, well, I've written down everything I want and I've put it in my desk drawer. That's not going to be enough. You need to make sure that it is a proper will because it is signed, witnessed, and notarized. The other piece of that is making sure your will is easily accessible. We see a lot of people that maybe don't want to share what assets they have with their loved ones. And that's fine, that is your prerogative, but what is most important is that you share where the will is. So keeping it in a safe drawer in your office or your desk. making sure it's in a safe deposit box and somebody else has access to that safe deposit box. Those are all very important pieces of this equation, because when you've passed away, it can get complex in the court system. People don't know where to go to find that will or how to carry out your wishes. And so without letting your loved ones know, they're not going to be able to access your assets the way that you would want them to. We see that often. I think today, as I mentioned, the biggest thing is to take away making the estate plan, and one of the big pieces of that estate plan is having this difficult conversation with your family. We see a lot of people that just don't want to have the conversation about what if, and unfortunately it is a tough conversation, but it's a necessary one. We need to discuss with our loved ones what is in our will, where is our will, and what are our wishes. You've worked your whole life for your assets, what you have, and what's important to you, and you want it to be carried out when you pass or a loved one passes. You want that to be taken care of in the way that you would want it to go. So I'm going to open it up in a minute for questions on wills, but I implore you to make sure that you leave today understanding that you'll have a will as part of your estate plan. We'll also touch on healthcare proxies, the trusted individual who can make healthcare decisions for you when you become incapacitated. And as I mentioned, this is kind of the lower tier under the guardianship. So you'd rather have your healthcare proxy in place. You put certain things in your estate plan for what should happen to you in certain elements if you needed a feeding tube, and you can make those decisions while you're well and thinking of them. If not, the alternative, like I said, is the guardianship, and then that's the lengthy court process that you'd like to try to avoid as well. And then, of course, the power of attorney, and it authorizes your healthcare agent to act on your behalf, handling your property. So also an important document. So handling your business matters, signing those checks for you, cashing those checks for you, an important document to have in place. I'm sure the Senior Center has some great resources on how to set some of these forms up. If not, there is some information in your bags as well. But all essential documents that you'll need to have, again, as important as your will, letting people know where the documents are. I've heard some great tips about putting them in your glove compartment of your car. That way anyone can access them at any point should they need to. If there's an emergency situation, you want your family to know how to get access to these documents so they can carry out your wishes. With that, this is our contact information. It's also in your bags and your resources. We are always available by phone. We are always available for you to come in. We've now launched a virtual registry. I don't know if you're accessing the computers at home or at the Senior Center, but we have a link. It's on the back of your bags to the virtual registry, and you can just sign right on and access us anytime online via Zoom. We'll answer your questions there. As I mentioned, we'll have our table set up in the back, and we can either call you back if you have specific questions, leave your contact information, or you can call us at any point should something come up after this presentation and you want some more information. I would like to open it up to questions. I think this looks like a great group with some good questions. And as I mentioned, if we can keep them more general and broad to answer for everybody, and we'll help guide you and tailor it so that you are getting the information you need from the Probate and Family Court. Do we have some questions out there? Yes, sir. The question was, why aren't springing power of attorneys recognized by institutions and banks? We have a lot of questions, probably more than any, about why do banks do what banks do? And I unfortunately don't have the answer for that. I don't know why banks recognize what they recognize or do not, but I have done this presentation in the last week a couple times and gotten more questions about banks, and unfortunately I don't have the answer. I think what we're tending to find is that since banks are generally national branches, they follow broad laws. Probate law is Massachusetts or state specific, so we're following exactly what is going on in the Massachusetts state laws, and I think that's mostly what we're seeing to encompass the answer to your question, is that they follow more general, broad, national, and we're just focused on Massachusetts state.
I would certainly put that in your will, because your healthcare proxy is going to terminate at the time of your decease. That's a document for while you're still living. So anything that you're going to want. Yep, you picked the healthcare proxy.
So why
Because the healthcare proxy is a document that allows them to make medical decisions while you're living. Yes, your will is going to dictate what happens after you pass away.
He's exactly right. An important piece that should go in your will, and again, part of a conversation with loved ones, so they can know that beforehand as well. And with that, I do want to harp on just the idea, and I'll answer more questions, of making sure your will is up to date. We had mentioned the personal representative. Oftentimes people make a will, it sits there for 30 years. Your personal representative may have passed on. They may no longer be in your life in that capacity to serve as a personal representative. Anytime there's birth, death, marriage, divorce, any major life event that you see in your life or that of your family, it's important to update your will. In the physical office, the 80s, but we have archives of cases. So a unique tip or fact is that this is one of the oldest positions, Register of Probate, came over from England, 1700s. So I guess there's probably records somewhere going way back to then. I don't have them, but we do have some. We have archive cases that have. So that's another big thing that we've been working on, a huge push, is to try to digitize all of the records. And so not all 800,000 have. I think we started digitizing the whole court system in 2010, and we've been, since I've been there in 2014, 100% digitized, but some of the old ones are still working on the archives. So we have a lot of people that are genealogists that come in, they study these, and they can access all of those cases. Yeah. Yeah, no, you need to have two witnesses. So I don't know how, was it notarized? Yeah. Two witnesses. And see, those are things that you're going to want to pay attention to and double check. As I mentioned, we were with a woman last week who just had what she believed was a valid will, and she wrote it on yellow line paper, and that's not going to stand in court. And that's what we see. And then you don't expect your daughter to come in and say, but this is exactly what my mother wanted, but then your son says, no, it's not, and that's where it all begins. So it's so important that you button that up. She'd like to know the difference between a will and a trust, and so we briefly touched on that. The will is going to be your roadmap, what you've set up for how your assets will be distributed. The trust is more of a vehicle that's going to protect your assets, and then they're distributed by the trustee in a certain way that you've laid out. So trust is a lot more complex, and it's not something that I can get into today or would get into. That is where you'll certainly call a trust attorney who would set that up for you. There are many different types. You had mentioned you think you need a certain type of trust, and there are many different types of trusts that
have referrals.
So like I said, I call the Worcester County Bar Association lawyer referral. So it's right in your packet how to access them. So there's an association of all the attorneys in Worcester County, and if you call that number, they'll go ahead and you tell them why you think you need that certain trust or what you think you're trying to do with your estate plan, and they'll get an attorney that's really qualified and easy to work with and right for you. They'll try to match you up as best they can and get that set up for you. I would assume so, yes.
Yeah, you can have multiple trustees.
Just like you can have several personal representatives, yes. So the question was, if it's written by you, is that a legal will?
Everything on it had to be written.
And so, yes, that is the point. So what you're looking for is a document that's drafted. It can be handwritten. You can write it on a napkin. You can fill out one of the forms online. I think the best is to work with an attorney who's specialized in this, but as long as it's written and then it's notarized, witnessed by two people, and signed by you, that is a valid
So
will.
why did the lady with the yellow legal pad?
She never had it notarized or witnessed, she just wrote down her notes.
Okay.
And so your notes alone.
Without a-
I think it's also important to note that when you've made notes on your will, that could invalidate your will, so you won't want to do that either. Those won't be taken into account in court. So certainly if you need to make changes to your will, you need to take the proper legal steps to do so. You can't just add notes in the margin and hope it stands. So we'll take a couple more questions if you have them. If not, as I mentioned, we have our resource table in the back, and so we'll stay there for a little bit until lunch is served. If you have specific questions or you're looking for paperwork, we can pull anything up online and get you any additional information you'd need. But it's certainly complex. Hopefully you've received some information to at least get you started thinking about your estate plan. Like I said, we'll be here. We can answer some more detailed questions or specifics if you have any of what's going on in court, if you have a specific case. We'll be right up at that table. But I thank you for having us today, and hopefully you leave at least thinking of your will and your estate plan and those important documents in your family. So thank you.